Thank you very much. Today, I think it's my great honor to be invited to attend this very great event. And my topic is foreign relations law and extraterritorial application of Chinese law. Well, we all know that on June 28th this year, the laws on foreign affairs, foreign relations of the PRC was adopted by the Standing Committee of MPC, which came into effect on July 1st, 2023. In summary, the foreign relations law provides for the first time a comprehensive framework for China's foreign relations. The stated aim of the law is to safeguard China's national sovereignty, national security, and development interests, and uphold international fairness and justice. So my presentation today focused on the key provisions on the extraterritorial application of Chinese law. But in order to help us to understand these key provisions, I'd like to go back first to the background of the extraterritoriality of domestic law. We all know that the international system stemming from the 1684 Westphalian treaties established national sovereignty and territorial integrity as supreme principles of international law, thereby making territoriality a defining pillar of the traditional international law. However, I should say that since the 20th century, this principle of territoriality has come under substantial challenges. And the United States, of course, is playing a leading role in overriding this principle. In the past century, and also during the 21st century, the U.S. legal doctrine has bypassed traditional territorial limits in favor of extraterritorial jurisdiction on the various doctrinal banners. I think that China, as the second largest economy, or some people believe that is second world power in the world, I think seems to be caught in a dilemma to some extent. On the one hand, it is one of the targeted countries whose entities and citizens have been sanctioned by U.S. authorities based upon the territoriality of the American law. For example, our high-tech companies such as ZTE or Huawei was on the list of the sanctions posted by the U.S. government. And more Chinese officials, Chinese entities, and even the universities are also on this kind of list. On the other hand, in recent years, China is now extending its domestic law over the territorial borders, to some extent tracing the steps of the United States. And during the last few years, I believe that more and more Chinese laws incorporate provisions on territorialities. So in this connection, I should say that the first time that Chinese central authorities to state its intention to build this kind of extraterritorial of Chinese law happened on February 25th, 2019, because on that day, the President Xi Jinping presided the second session of the Commissions of Overall Law-Based Governance of the CPC. And the news bulletin stated that the country should take efforts to accelerate the construction of a legal system of the extraterritorial application of our domestic law. So this is the first time that the Chinese leadership expressed its ambition or its intention to establish this kind of system at a time when China was embroiled in an intense trade war with the United States. So I should say that to foreign observers, to foreign experts or international community, it is a little bit confusing. On the one hand, China opposes the U.S. practice of so-called long-arm jurisdiction. However, it has decided to build its own legal system of extraterritoriality. So how to explain this, paradoxical phenomenon to some extent? So I'd like to elaborate this kind of paradoxical phenomenon. So first of all, let me explain the extraterritoriality versus territoriality. Well, we all know that in principle, law of a country has effect within its territory. So that is the traditional principle of domestic law. However, extraterritoriality means an exercise by state, a prescriptive, adjudicated, or enforcement authority over conduct outside state physical territory. And since the 20th century, you can see that more and more domestic law has the extraterritoriality. And frankly speaking, nowadays, I should say that to some extent, the extraterritorial application of domestic law does not necessarily conflict with international law. And however, Chinese government vehemently opposed the U.S. practice of long-arm jurisdiction. So I think that there is a different interpretation on so-called long-arm jurisdiction. As private international law scholars, we are all familiar with the meaning of the U.S. law on long-arm jurisdiction, which actually is a term used in international or interstate civil jurisdiction. However, when Chinese governments criticized the U.S. practice of long-arm jurisdiction, it usually refers specifically to the U.S. practice of unilaterally imposing the sections of foreign entities and lists based upon the extraterritoriality of domestic law without any reasonable basis or justification in international law. So in this regard, when Chinese government criticized U.S. practice of long-arm jurisdiction, it means something else, which refers to the unlawful misuse of U.S. domestic law without any justification in international law. And so I should say that when China decided to build a so-called extraterritoriality of domestic law, it of course means different from the U.S. practice of so-called long-arm jurisdiction. So let me explain a little bit about the current Chinese legislation, which has extraterritorial rules. So far, I should say that more and more Chinese law contains the rules of the extraterritorialities, but all these rules are based on the jurisdictions recognized by international law. For example, the Article 7 of the Criminal Code, Article 37 of the law of the China on safeguarding national security in Hong Kong, Israel, and so on. They have the extraterritoriality rules based upon the active personality principle. And Article 8 of the Criminal Code has the extraterritoriality effect based upon the passive personality principle. And Article 8 of the Criminal Code of PRC, Article 11 of the Anti-Terrorism Law of PRC, and so on, they reflect the principles or the jurisdiction of the protective principle. And Article 11 of Anti-Terrorism of the PRC and Article 9 of the Criminal Code of PRC, they represent the universal jurisdictions. So, and also there is some Chinese law, for example, Article 8 of Anti-Monopoly of PRC, law PRC, they represent the effects doctrine. So we can draw the conclusion is that, yes, so far Chinese law, more and more Chinese law contains the extraterritorial rules, but unlike America, these kind of extraterritoriality rules, they have the justification in international law. And so far, there is also a number of Chinese practice in this kind, which includes both judicial practice and the practice of administrative agencies. In case of the judicial practice, there is a number of cases, such as the Kunming Municipal People's Procuratorate versus Nancom AL, which is a very famous case that Nancom and his scam man slaughtered Chinese men in the Golden Triangle. And in the end, the Chinese authorities, they extradited the Nancom scam man and bring them to justice before the Chinese court and sentence them to death according to a criminal law of China. And the rest of the case also, are the typical cases where the Chinese court applied Chinese law extraterritoriality, are based upon the extraterritorialities. And in case of the practice from administrative agencies, basically they used to focus on the anti-monopoly cases. So apart from the competition authorities, the Chinese administrative agencies in general, for many decades, have been reluctant to enforce Chinese law over extraterritoriality in pursuit of the Deng Xiaoping strategy of keeping a low fine in international affairs. However, since the 2012, especially after 19th National Congress (CPC) in 2017, I believe that the situation changed significantly. Nowadays, Chinese administrative authorities, they are more likely to apply the Chinese law in extraterritorial effect. Oh, okay, can you hear me? Okay, so we can now draw a conclusion now. The Chinese law and the practice suggest that China will not in ordinary course of things assert or exercise extraterritorial jurisdiction unless there is a genuine connection between the subject matter jurisdiction and territorial basis of the PRC. And so far, Chinese law is quite very different from the US unilateral style of this kind of foreign policies. So let's go back to the Article 33 of Foreign Relations Law of PRC, which provides that China shall, in compliance with fundamental principles of international law and fundamental norms governing international relations, strengthen the implementation of the application of law and regulations in foreign related field, as well as take law enforcement and judicial measures in accordance with law. So frankly speaking, this law does not use specifically to the extraterritorial application of Chinese law, which use term of foreign related fields. These terms, I think, is wider than the extraterritorial application of Chinese law. Therefore, extraterritorial application refers to the enforcement of laws, countries' law beyond its borders. The mention of related, foreign related field in Article 33 of this law suggests that China will make further steps to implement applied law to foreign persons and or conduct. So actually, the foreign relations law itself does not provide a specific articles to build a system of the extraterritoriality of Chinese law. It just provides a more, I should say, a way or abstract articles on that. So in the end, I like to say that because the foreign relations law lacks concrete articles on the extraterritoriality of Chinese law. So we hope that in the future, more and more Chinese law can be improved to reflect the extraterritoriality of domestic Chinese law. However, there are a number of suggestions to this kind of construction of extraterritoriality of Chinese law. For example, we believe that multilateralism should be the cornerstone, which will be in sharp contrast with American practice of unilateralism. Some foreign observers believe that the extraterritoriality of domestic law in a nature is a unilateral exercise of sovereignty. So how can you argue that multilateralism can be used as a cornerstone? I think otherwise. For example, if you look at the case of Norcom, in that case, the Chinese policeman does not send their enforcement troops to the foreign countries unilaterally. In the end, in the day, the Chinese government signed a multilateral treaties with Burma, with Thailand, so to build a multilateral law enforcement cooperation mechanism. So in that way, we can say that enforcement being used in foreign jurisdiction. However, it is based on unilateral treaties, which is very different from the American style. Second, I should say that when we build this kind of Chinese system of extraterritoriality, we should put the political and economic interest as a priority interest, because for a country like China, we have different aspects of interest. However, nowadays, I think that we should do this, or we should construct this system step by step. And third, so far we find that the Chinese administrative agencies is more and more active to apply the Chinese law based upon extraterritoriality. So we believe that in future, the check and balance mechanism can be established. And I particularly believe that the Chinese People's Court should play a role in this kind of check and balance mechanism. Because if you look at the United States or other countries, you'll find that usually the courts plays a very important role to, to explain on what conditions that domestic law should be applied over foreign entities and foreign conduct. So I believe that the Chinese court should play a more active role. However, so far Chinese court is not that active. So I believe that my last suggestion is Chinese court should play a more active in building a system of extraterritoriality of Chinese law. That is the conclusion of my presentation. Thank you very much.